This is Chapter 1, Part 2, Lecture Video. Slide 16, the defense. The defense carries the burden of persuasion to show the prosecution has failed to prove beyond a reasonable doubt. They've failed to prove the case. They've failed to prove the elements of the crime. And can raise affirmative defenses. They can claim self-defense, duress, intoxication, entrapment, insanity. And the burden is on the defense to prove that. They can attack the constitutionality of how the evidence was obtained. Slide 17. The defendant has the right to counsel. It's guaranteed under the Sixth Amendment. And if denied, any conviction would automatically be reversed. Defense attorneys must be reasonably competent. If the defendant is too poor to afford an attorney, the state must pay for one. Slide 18. Just in summary, Gideon versus Wainwright, the court held that the right to counsel must be provided if the defendant can't afford one. So that was the first case that backed up that Sixth Amendment. Slide 20, the defense attorney's duty is to ensure due process of law, to protect the defendant from illegal searches and confessions, to cross-examine hostile witnesses, and ethically to not engage in or promote fraud, to not file or seek frivolous claims, to not present false evidence to the court. Let's look at page 12 of your textbook. First paragraph. Let's see here. I'm trying to decide if I want to read this. Defense motions to suppress evidence found during searches or confessions activate the defendant's Fourth and Fifth Amendment rights. The Sixth Amendment designates the jury as the body that determines if the prosecution has met its burden of proof. Let's skip on down to the fourth paragraph. All attorneys have an ethical duty not to put on false evidence. The attorney has an ethical duty to intervene if it appears that perjured testimony is planned or that witnesses will be intimidated. This may include notifying the court if material statements were made that were not true. Attorneys have a duty to accurately state the law during arguments and in their briefs. Care must be taken to avoid citing cases that were overruled, or to take quotes out of context, and to present portions of dissents and concurring opinions as the holding of the court. So this is ethical binding. Slide 21, History of the Rules of Evidence. Historically, trials were often unfair. The Star Chamber and Inquisition started with a presumption of guilt. Jurors had to have personal knowledge of the case. So actually the jurors had to get to know the case before it even started. And they actually could conduct their own investigations, which is kind of crazy. A juror would conduct their own individual investigations, like Sherlock Holmes or something. Few rules existed to keep bad evidence out, and hearsay was admitted like crazy. Not a problem. So there was a reform, and it was the Uniform Rules of Evidence. Many, many, many rules. And we're going to hit on a lot of them this semester. They were proposed and developed, and even today, states have different rules from them, but they are spin-off from them. Slide 22, Sources of Evidence Law. The U.S. Constitution, our Bill of Rights, as interpreted by the courts. If you look on Blackboard, I have our 10 amendments, the Bill of Rights, the 10 amendments of the Constitution listed on Blackboard, so you can look through them as a reference. The U.S. Supreme Court, it defines what the Constitution means, and it supervises the federal court system. The Federal Rules of Evidence was adopted by the Supreme Court in 1975 and enacted by Congress. It was adopted by many states. Slide 23, Sources of Evidence Law continued. State Supreme Courts interpret their own state's constitution. State rules of evidence, many follow the federal rules of evidence, but others have adopted their own unique rules. Case law. Courts have to explain or interpret what the law is, and sometimes there may be conflicting laws or cases that may conflict with legislative intent. So case law comes into play. Slide 24, Cases and the Evolution of Law. The rules of evidence evolved with society and technology, as shown by Supreme Court cases. So rules of evidence, they change as there are Supreme Court cases that are brought up. In Katz versus U.S. 389, the Supreme Court developed rules about expectations of privacy. In U.S. versus Jones, the court first applied those rules to GPS devices. Let's look at page 14 and 15. Page 14 of your textbook, the very last paragraph. The U.S. Constitution is not static. Each year, the U.S. Supreme Court rules on a variety of cases. Every one of these decisions in some way interpret the Constitution, the Bill of Rights, or federal statutes. This process has allowed the Constitution to be a living document. At the bottom, early cases interpret, and at the top of page 15, Fourth Amendment's protection of persons, houses, papers, and effects, literally, but this became problematic when considering wiretaps. A wiretap is listening in on someone through their phone, their cell phone. We'll talk more about that later in the textbook, chapter 14, I believe it is, on what constitutes a wiretap. The court developed the reasonable expectation of privacy in Katz versus U.S. as a better analytical tool. Toward the bottom of that paragraph, United States versus Jones held that a search warrant is required prior to attaching GPS tracking devices to the outside of an automobile. Where there are no provisions of the Constitution or Bill of Rights involved, the U.S. federal system allows each state to enact its own rules of evidence. Just below the United States Supreme Court, two important functions of the Supreme Court should be noted. 1. The court is the final arbitrator of the meaning of the U.S. Constitution. And 2. The court acts as supervisor of the federal court system. Decisions of the court that interpret the Constitution are binding on all federal and state courts. When ruling on the meaning of the Constitution, the Supreme Court has the authority to overrule any court in the nation. It also has the power to overrule its own prior decisions. Gradual changes can be seen in the court's decisions as justices retire and are replaced. Let's look at slide 25, legal research. Comprehensive legal research. Actually, let's skip to slide 26, where it talks about legal research. Court opinions are found in multiple locations, public and private. An example of a case citation, which will be discussed more later in this book, is Miranda. Miranda versus Arizona. It was an appellate case lost at trial. Arizona was the appellee. It was found in volume 384, United States Supreme Court reports, starting on page 436. So we'll talk more about Miranda this semester. And that is the end of chapter 1.